there are a million hard questions in this case, and it is an emergency application, and very difficult questions, either no precedent or very conflicting or very uncertain body of precedent. But there are two things were decided by the lower courts. One, that what I just explored. The district court said it's got to be in-office conduct, nothing that happened before person took office counts. And then the D.C. Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the D.C. Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument. And I do want to talk about best reading a shirt left.
Why wouldn't that